two don't go together. I don't think we become more political in our output. So far as challenging government policy is concerned, if we differ from government policy, it's on the ground that government has adopted a policy which is unlawful. It's our job to review government action to see whether it accords with the law. That's not political activism, that's simply doing our job. Having said that, the growth of judicial review has marked a growing trend of intervention in government by the judiciary. Government only intervenes at the suit of citizens, so there has been a growth in the challenge that is brought by citizens or organisations of government action in the courts. That's been a very marked development in my lifetime of the law. And the diet of our court now is very largely a diet of public law. When 40 years ago when I started, a lot of the work done was commercial law, tax law. It was a quite different diet, but there was very little public law reaching the House of Lords in those days.
Yes.
It wasn't a question of moral debate, there wasn't any debate whatsoever.
Yeah.
Everybody agrees that it was a highly unsatisfactory way of introducing important constitutional changes. There's quite a lot of debate after it was announced as to what should happen, as a result of which the Lord Chancellor wasn't abolished, but his functions were altered. But it was an extraordinary way to set about constitutional change, which I think is something that everybody now accepts.
So what was your view when you first found out about the creation of the Supreme Court?
Well, first of all, astonishment. I was actually, at the time, at a two-day seminar of the top members of the Judiciary, the most senior members of the Lord Chancellor's department. They didn't know what was coming, and so the seminar got off to a rather shaky start when it was announced that their department was being abolished. And initially, the judges were not in favour of the abolition of the Lord Chancellor, because he had been a very good ally over the years of the judiciary. It was his job to stand up for the rule of law and for the judges. And Lord Chancellors in the past had done just that, including Lord Irving. So the initial reaction of the judiciary was, I think, hostile to the abolition of the Lord Chancellor. As we considered the situation, I think we came to accept that it was an anomaly, and that there were good reasons for the change that was being introduced. I can see that situation in theory, but I don't think it's a realistic one. The example one can give is what would happen if the current administration decided to pass an act saying that their period in office would be extended by 5 years, and push that through Parliament. It's unthinkable that any government would attempt to do such a thing. If they did, there would be a public outcry. Somebody, I suspect, would bring a legal challenge, and faced with this scenario, there would, I think, be a possibility that the courts would simply say this was going too far, there are some unwritten rules of our constitution which Parliament is no longer in a position to alter, and that's one of them. I don't think we are. I think we're seeing a decreasing number of judicial public inquiries. They used to be more common. Some of the recent ones have proved to be extremely expensive. And so government is much more reticent about launching a judicial public inquiry. There are lots of inquiries going on, but there are not all that many that are being chaired by High Court judges. Before a High Court judge agrees to do an inquiry, he will consider very carefully the nature of the inquiry, and he will no doubt also take advice from the Lord Chief Justice. And a judge won't accept an inquiry that's of a political nature, or shouldn't do. the criteria of a Supreme Court Justice is laid down in the Constitutional Reform Act. It is open to who are not judges to apply, and there's no reason at all why a practicing member of the bar shouldn't apply to be considered for the Supreme Court. But the role of the Selection Commission is to consider the relative merits of the applicants, and if you've got a very powerful track record as a senior judge, you're obviously off to a very good start.
Yes.
If one's going to prefer a candidate who hasn't got that kind of record, then that candidate is obviously going to manifest very powerful alternative qualities. Not in reality. The Lord Chancellor has, under the statute, a fairly limited power of veto. He can't actually nominate anyone himself. It's up to the Commission to provide the nomination. And the Lord Chancellor can invite the Commission to think again and to produce another name, but he's certainly not in a position himself to appoint a member of the Supreme Court. No, I don't think so at all. The Commission is apolitical. It has a lay majority, but quite strong judicial representation. It was set up to distance the appointment of judges from politics, because prior to the Commission, it was for the Lord Chancellor to recommend who should be appointed as a judge. Now, in practice, the Lord Chancellor took advice and made appointments on merit as a lawyer or a potential judge. But the appearance, again, was at odds with the concept of the separation of powers, because here was a member of the executive, although the Lord Chancellor was rather more than that. He was everything. He was a senior judge, he was a senior cabinet minister, and he chaired the proceedings in the House of Lords. But nonetheless, he it was who had the say as to who became judges. Now we have an independent commission which is apolitical, and it will remain apolitical unless the law is changed and the system is changed. No, I don't think there's a conflict of interest anymore. It might have been said that there was a conflict of interest, there could have been a conflict of interest when the Lord Chancellor presided as a judge in the House of Lords. In fact, the Lord Chancellor was, certainly in recent times, has been very careful not to sit, or to try not to sit, on any case in which the government has an interest. But now, the task of the Lord Chancellor as Minister for Justice is to provide the infrastructure of the court system. And I don't think that puts him in a position of conflict of interest.